Now, the next topic that I want to cover is a settlement hearing. So now we've described the first meeting with the client, claim, defense, and the next issue that comes up is a settlement hearing. If nothing else happens in terms of your settlement in the proceeding, then at a certain point in time, usually a few months after you have filed your claim, the court office will set down a hearing for the settlement. So a settlement hearing is court-ordered procedure with a date prescribed by the court in terms of the settlement, and is brought before usually a deputy judge, or there are special people sometimes who are mediators, are also allowed in certain courts to mediate a resolution of the settlement between the parties. So you get a notice from the court office, both the parties get the notice to say on this date, you will have a settlement hearing. The normal time allotted may be slightly different in different courts in Ontario, but essentially it is about half an hour, 45 minutes. It may go a little bit up or down, but they are set aside normally 45 minutes time frame slots for you to come there with your client, and you have before the judge a hearing to decide if you are ready to settle the matter. So if you're acting as a lawyer or a paralegal for a client, what would you do? You can either follow through, as many in my experience do, that they take the matter and just wait for the judge to do on his initiative, discuss what is it that you would like to do in the file. But I think in my view, if you want to use this procedure actively, and I would encourage the lawyers and paralegals to use this procedure more actively to try to find a resolution of the problem. And what can you do? I think in more recent years I've seen a whole bundle of documents prepared for settlement hearing which are not required, but you could use them, and I think it's a very good idea to create a settlement hearing documentation in which you can outline your position, insert the documents you're going to use if you go to trial. You can also present some case law and create almost a brief to prepare the other side and the judge to get an opinion of the judge. Now, the settlement hearing is for the purpose of identifying between the two parties what is it that the parties agree on and what is it that they do not agree on. And essentially, without going through the evidence in a formal fashion, the judge will offer sometimes a thought, opinion, which can be very helpful in terms of the resolution of the problem. So depending on the style of the judge, he will open the proceedings and ask each side what the position is. This is what I did in my settlement hearings, and I asked each side what the position was. And the reason I did this is because it encourages people to verbalize their grievance. It enables them to frame the line of thinking to decide what is it they want from the court hearing. And when the other party hears that, then it begins to focus their minds on what can they do to find a solution. It's very important in my view that you come with an open mind and with your client and bring them to the court so they can hear the other side. And in many situations, if it's properly prepared and you keep your mind open, a resolution is possible. So if you haven't noticed to prepare for a settlement hearing, I would suggest that you prepare for it. You prepare the client for it. You create some notes, your documents, and you're required to prepare the documents and provide them to the opposing side 15 days before the date of settlement hearing, so that the other party has an idea of what is it that you're going to bring in terms of documents to prove your position. There's also the list of witnesses that you can provide, and that gives the idea to the opposing party what witnesses will give evidence. It doesn't tell you the content of the evidence, it tells you who the witnesses are. So a settlement hearing, from the point of view of the procedure, is designed to see if a settlement is possible, and in many cases where there are paralegals and lawyers involved who have reviewed the matter with their clients and they see that they have a possibility of settlement, then in many cases a settlement is possible. And my observation is that the settlements are not as frequent in the small claims court as they are in superior courts, where the expenses are very high, and the lawyers have given much more thought to what is it they can achieve at trial, and they would encourage their clients to settle on certain lines of the issues of the compromise they would be willing to make. And now, once you're in the hearing with your client and you are getting the comment from the judge, what happens is that the judge's unbiased opinion can persuade your client. If your client is asking you to push for the limit, then the hearing of a comment from the judge can make a very big difference in his mind, because you're acting as a lawyer. Your duty is to serve the client. There's a duty of loyalty in the rules of professional conduct. So in the relationship of a lawyer and a client, you are already, so to speak, biased in favor of your client, and there is a tendency to see the problem from your perspective only, meaning your client's perspective only. So the settlement hearing gives you an opportunity to reflect what the other side is saying. And if you keep your mind open, I think, in my view, you're doing service to the client when you in fact recommend a resolution of the problem and show to the client how to see the problem in a more objective fashion. I think, in my view, one of the roles that we play as lawyers and paralegals is to try to bring certain amount of objectivity into the process, because when a person is so engaged in the dispute that it is very often difficult for that person to see the point of view objectively. You're also bringing the question of evidence and the law to the client, and that played out in the settlement hearing with the discussion that happens also enables your client to see that notwithstanding your bias in favor of your client and all the discussion that you had with the client, there is another objective opinion that you're getting. Now, there are rules in the small claims court that set out actually the different things that a judge can do in a settlement hearing. One of them is that if you agree, you can even write out your settlement. And there are two ways you can do this thing. One is that you agree to settle, and if there's a payment to be made, you agree the terms of payment. The two parties sign. These forms have been formalized, and they're very often available in settlement hearing situations which you can use, and you don't even need the judge to sign. And there are some wording in that settlement agreement that if the party does not carry out their obligations, the other party unilaterally can go to the court and obtain a judgment. So that enables the parties to know that the settlement arrived at in the settlement hearing is going to be of significance to carry out the resolution agreed to between the parties. Now, in terms of the judgment, the judge also has a right to make a judgment on that issue. Now, many parties, lawyers and paralegals I saw, they do not see the distinction between the two quite clearly in legal terms. So let me just explain how it works from my point of view. Is that a settlement agreement is an agreement to be carried through like an agreement. A judgment is enforceable as a judgment and can be carried through from the procedural point of view to enforce a judgment with the full force of the law. So if you decide in the settlement hearing that you would like to consolidate that decision in the form of a judgment, then you can both by consent ask the judge. The judge will be very reluctant to write a judgment unless there's consent, because his obligation is to make sure that if a person wants a trial, and the trial will present the opportunity to both the parties to tell their case, then the judge wants you to have a trial, because that's the time when you can make a fair and a reasonable decision based on the law and the evidence. But if you do decide in consent, the judge would have the right in the power to endorse a judgment, and if it is a judgment, that is fully enforceable as a judgment. So I think the summarizing the role of settlement hearing, it is a procedure in the small claims court created to find a common ground and enable the parties to find a resolution of the problem without going to trial.